Of our Community Associations Building Block webinar series. Today's session will cover the topic of annual meetings. I'm Jen Ritter-Tavasek, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. If you have any issues with video quality or sound quality during the presentation, please reach out to me via the Zoom chat feature, and I'll try to troubleshoot with you. We're going to kick off the presentation today with an overview of annual meetings, but then we're going to jump right into Q&A. So we want to hear from you. As we begin the presentation, please type your questions into the Q&A box, and Adam will address those in the middle towards the end of the presentation. I'm going to turn the mic over to Adam Bowden, and we can begin.
Thanks, Jen. And if you are not prepared for the next 40 minutes to an hour on annual meetings, I suggest you just drop right now, okay? So once you buckle up on this wild ride, there's no turning back. So annual meetings, I'm going to do an overview. And then as Jen mentioned, we really want this to be a solicitation of your questions. That's the way this webinar is gonna be and how we're going to proceed. So North Carolina law requires that all incorporated community associations, and I'll stop there. A community association can be a townhome community, it can be a over 55 community, it can be a condo, it can be single family, it can be garden, patio homes, whatever. But when I say community association, it's all encompassing of any incorporated nonprofit which acts as a community association. So North Carolina law requires that each year your community association hold an annual membership meeting. And so what's the purpose of the membership meeting generally? It's likely that you're going to elect a director or some directors at that annual meeting. It's likely that you're going to vote, or not necessarily vote, but you're going to ratify an annual budget. There are some exceptions for pre-47F communities, that is any planned community created before January 1, 1999, does not have to have the budget ratified under Chapter 47F. May be required in your documents, but it's certainly not going to be required by the statute. But so annual meeting, you're going to elect directors. You're going to ratify the budget in most cases. If you're not ratifying it, at least the board is going to present the budget and explain the amount and the reason that you're going to have the assessments that you're going to have for the upcoming year. Generally, the association will adopt a tax resolution, which allows them to avoid paying taxes on any assessments from the previous year that were unspent, that we can put those in reserves, as well as possibly any amendments that are up for the articles, bylaws, the declaration. It could be that you might be having a special assessment, but generally that's the reason that you're required to have an annual meeting of your membership. Most communities only have this one meeting, right? It's pretty common, and everybody was lockstep, and all community managers knew how to do it up until COVID hit last year, and the governor provided some relief with several sets of executive orders, most principally one that allowed virtual meeting attendance for membership meetings for nonprofits and for corporations. Of course, those orders, as we sit here today, have expired. So virtual membership meetings are no longer a thing. They're no longer legally allowed. There are two bills that are kicking around in the House and in the Senate. I've looked at both of them recently. They're both in committee right now. And as a board member on the CAI board, I know that we at CAI have came up with the language for the House bill. There's a competing bill in the Senate. Long story short, it is very likely that one of these two pieces of legislation are going to become law probably by the fourth quarter of this year, which means that going forward, once those bills become law and signed by the governor, which all indication is that it will happen. There's not any fighting going on. Let me put it this way, regarding the utility and the value and the importance of making it permanent to allow virtual membership meetings in North Carolina. And so it's really what's going on right now is the House and the Senate are fighting with each other over who gets credit for it. So what's likely going to happen is they're going to make peace. They're going to create a merged bill that they both support and try to see how much joint credit they can take for it. But that's not going to help anybody right now that's having to plan for their annual meetings. And so, last year we were able to be very flexible, and we were able to do it like this with a webinar via Zoom. We're able to do over telephone calls. We're able to do a bunch of different ways so that the associations can continue to conduct business. Most importantly, right, getting that budget ratified so that you can increase your assessments to handle things that need to be done under the governing documents. And so when we had the walk back, right, in terms of no more virtual meetings, we're now under traditional once again. Now, that doesn't mean that you may or may not be able to have some kind of informational portion that's virtual, but it basically means that the business that is going to be conducted at the annual meeting either has to be done in person with proxies, of course, because I say in person, essentially in North Carolina, means that either you are there in the seat or you have sent somebody in your place to vote at that meeting in your stead. And so that's what a proxy is, right there. You've heard the term attorney in fact thrown out a lot, but that's what a proxy is, right? A proxy is not a ballot. A proxy is not an absentee ballot. It is a document that allows someone else to take action on your behalf, in your stead, if you will, at that meeting. So the bad news is if you give your proxy to somebody and they, let's just say, unfortunately contract the Delta variant and they can't be at the meeting, you're not at the meeting either. And so that's a challenge that we have to think about, right? So annual meetings you can attend in person, which includes actually in person or by proxy. Or you can take most of the action that you're going to take at that annual meeting. You take it by this thing called written ballot. You can do action by written ballot. Several years ago, I wrote an article about this. Proxies, or written ballots are from Venus and meetings are from Mars, kind of thing, where it describes the difference. So what is a written ballot? A written ballot is essentially a term of art. It's not the ballot that's passed out at a meeting, okay, when you're at in person, right? It's not this anonymous piece of paper that's pink, blue, yellow that lets you vote for board members or vote, for or against the budget. It's not, it's totally different. What it is actual written document that's signed by the member who's actually casting the vote in place of a meeting. And these two things cannot coexist in the same universe, okay? And what I mean is that if you're going to take action via written ballot, you can't take that same action simultaneously at a meeting. So I'm going to give you some examples of that, of how we've used pre-COVID, how some of the larger associations decided they were going to use a written ballot in an annual meeting context, which is to say, okay, look, we got a large association, 1,000, 2,000 people. It's really labor intense and inefficient and not a good use of member time for us to sit and collect ballots at a meeting for an election of the board. So what we're going to do is ahead of the meeting, we're going to actually have the election take place via written ballot. It's actually not going to take place at the meeting. And we're going to have the ballots returned to us the day before the meeting takes place, so that all we have to do at the meeting when it comes to the board of directors is to announce the results of that election at the meeting. And then you can have those newly elected board members can take over at the end of that annual meeting. And so that is something that we've done a lot, that associations enjoy when it comes to avoiding the labor intense, intense time that it takes to do these things. Plus, it also gets rid of any, what I like to call member nonsense, people grandstanding, nominations from the floor, people using a bully pulpit, things like that to try to get elected. Because since there is no election at the meeting, there is no ability for a nomination from the floor. So we have other communities that like that idea of written ballot, using it at the annual meeting, but they don't put the deadline being before the actual meeting. Instead, what they do is they have the deadline either run to the end of the meeting or run to the day after the meeting or a couple days after the meeting. And so what they'll do is they will allow those folks who are running for election to say their piece, why they should be elected, why they're a good candidate. And the folks at the actual meeting, if they haven't already sent in and returned their written ballot, they can turn them in during the meeting. Granted, the meeting, the vote is still not finalized or taken at the meeting. But these are some different ways. It just kind of depends on how you want to go through with it. Most associations don't use written ballot with respect to the ratification of the budget, because at an annual meeting, when we talk about ratification, and I want to preface this, right? As typical lawyers, we always say, you've heard me say it 1,000 times if you've been hanging out with me over the past couple decades at CAI or HOA USA events or our Warden Smith events. Ratification essentially means this. It means that at a meeting, which is usually the annual meeting of membership, unless a majority or greater number is indicated by the governing documents, unless a majority or greater number of members of the total membership, not those in attendance at the meeting, vote to reject the budget, it's automatically approved. And so the beauty of this, when the legislature enacted the Planned Community Act and the Condo Act, is that most associations don't even have a majority of their owners in attendance at the meeting, in person and by proxy. They don't. I mean, you're lucky to get 10, maybe 20, 30, 40% of the population. So you know immediately as a board, when you roll into that annual meeting, you've got the check-in desk, you know the quorum's satisfied, but you know whether or not that budget is ratified before you even present it. I've been doing this a long time, represent 600-700 associations. I've only ever seen a budget rejected one time. Well, I've seen it rejected 3 times, but it was all 3 times, 3 years in a row consecutively by the same association. And the reason that budget was rejected, right, and they had the horses to pull it off, are that a large segment of that particular association's members, that is a majority of the members in the community, had filed a lawsuit against the association and its board. And so by rejecting the budget, they were attempting to stifle the board's ability to increase dues to fund the legal defense of that lawsuit. They were trying to win the lawsuit by cutting the legs out from the monetary funding for the board. It didn't work. We ended up being victorious and successful for the client. It did take, as I said, took about 3 years. But what happens when members reject a budget, right? Well, what happens is that you go back to automatically back to the budget from the year before. So it doesn't mean that there are no assessments, and it doesn't mean that there are that we're starting from ground zero. It just means that you pay the same dues that you paid last year. There's no increases or decreases for that matter. One of the questions popped up, said, what were the 2 acts that I just mentioned? So the acts that we're talking about that require budget ratification is Chapter 47C. That's the North Carolina Condominium Act. Every single condominium in North Carolina, regardless of when it was incorporated and formed, must have its budget ratified by the membership. There is no exception. There is no grace from that. Chapter 47F is the North Carolina Planned Community Act. And so budget ratification for planned communities, that is single family homes, only is compulsory and required for those communities created on or after January 1, 1999. And quite honestly, just as a little aside, right? A lot of times I'll get clients that are what we call a pre-47F community. They're an older subdivision. They want to update their covenants. And they'll say, Adam, we want to do amended, restated articles, bylaws, declaration. So for those of you out there in virtual land, amended, restated governing documents simply means that we're replacing the existing articles or bylaws or declaration in its entirety with a brand new document. We're not just amending certain portions of it. I call it the surgical strike. Instead, we're doing a full transplant. And so when you do that, though, and you're a pre-47F community, you will then fall under Chapter 47F, and you will then have to start with budget ratification, which is one of the reasons that a lot of pre-47F communities, where the board has unilateral authority to set the budget without member vote at the annual meeting, they will opt not to do amended restated documents, but instead will prefer to do that surgical strike where we go in and either add or remove and or a combination of both some new sections or take away some sections or clarify some sections rather than just do a full transplant. And so those are the two. The Planned Community Act is Chapter 47F again, and the Condominium Act is Chapter 47C, just so when I say that, and I appreciate the question. So some of you, right, when we talk about annual meetings, I'm going to back up a little bit, right? So the notice requirements for annual meetings are not less than 10, no more than 60 days written notice. And so that means that if we're sitting around waiting for the legislature to, for example, have Senate Bill 410 become law, and our annual meeting is in November or December, well, if the legislature in the next 45 days gets their act together and allows virtual meetings, those of you that have meetings that are late in November or in December may be able to take advantage of the virtual meetings. But those of you that have your meetings, say in September, October, or early to mid-November, you're not going to be able to rely on the virtual meeting. And so I put that out there. So with that being said, I've spoken for 20 minutes here, and I've tried to give you a little bit of a primer on where we were, where we are post-COVID, moving into Delta variant, and what the likely future is going to be. And I will say one thing before Jen starts in with some of the questions that I know she's indicated she's gotten some outside of the chat as well. is that I'm going to be speaking next week in Las Vegas at the CAI national membership meeting. So if any of you are managers that are heading up there to get some of your credentialing, to keep your CAI, credentials in place, I'm speaking 9:30 in the morning on Friday. And so I'm excited. We'll be talking about what I like to coin as member nonsense during COVID. That is kind of a case study. Cynthia Jones and I are gonna do that. But we, as part of our presentation, we did a survey of all 50 states. Took a long time to do it. But what we found is that probably about 35 states before COVID already had legislation, that is statutes in place that allowed for virtual membership meetings. So this shouldn't really be any shock to anyone on this call that North Carolina, South Carolina, Tennessee, a lot of the southeastern states are trailing behind the curve when it comes to the ability to meet virtually. But I feel certain by the end of this year, North Carolina will no longer be in that list. And so anyway, Jen kind of hit me with some stuff.
Okay, great. Well, thank you, Adam. And I know some of these introductory questions you may have covered during your 20 minutes, but I thought I would ask them just for clarification for the group. So the first question we received is, does my association have to have an annual meeting?
I appreciate you bringing that one back up, Jen, because that happens all the time. Well, do we really have to do this? The answer is yes. There is no excuse for not having an annual meeting. Okay, you have to have it. Now, if you call it and you don't have enough members show up, at least you tried to call it. Okay, and so you're supposed to hold an annual meeting. If you don't, there can be some consequences, but we'll talk about that later. Hit me again, Jen.
Well, funny that you say that. We'll talk about that later. The next one is, what if we don't hold our annual meeting? What happens?
Perfect timing, right? I couldn't have scripted this better myself. So what happens if you don't hold your annual meeting? Well, a couple things can happen, right? So if the board members, when this happened before COVID, but I'm just going to give you an example. So if the board members decide, hey, we're not going to hold the annual meeting because we don't want to get removed from office, right? They want to stay in place, and they know that the members don't like them, and they know that they're going to get booted, right? That's what is a breach of fiduciary duty to the association. And so those members open themselves up for individual liability for a lawsuit. They also put themselves at peril for any actions that they take during that time that they failed to hold the annual membership meeting. And we're not talking about, like, if your documents say you're supposed to hold a meeting on the third Tuesday of September every year, and you hold it on the fourth Tuesday, or you hold it on the third Thursday, right? What we're talking about is people that stay entrenched long beyond their term. They're breaching their fiduciary duties, which means that it can cause problems and some breach of contracts and some other things with vendors. It just can cause a lot of trouble for you, right? And so you go to any court, they're going to look at the statute. It says you have to have a meeting. What's your defense going to be to the judge? It might have been, hey, well, there's COVID and we can't be more than 10 of us in place and there's no virtual meetings. Well, the governor got rid of that one for you, right? So you don't have that excuse in your pocket. But if you don't hold an annual meeting, it erodes the legitimacy of the action of that board that stays entrenched, and it causes all kinds of problems and individual liability potentially.
Thank you. And so a great question came up as you were going over that, Adam, and it is, most of our members live in other states and their neighborhood is primarily lots. Are they able to hold an annual meeting in person and Zoom at the same time in September?
Okay, so I'm gonna break this one down, and Beth Price, I appreciate the question. So right now, as it stands, virtual attendance at a meeting is not allowed. So could you, I'm gonna rephrase this, could you hold a meeting in person and allow members to view the meeting remotely, yes. But those people that are viewing the meeting remotely or virtually, they are not in attendance at the meeting. They cannot vote, they cannot participate in the meeting. So if you want to handle it that way, those people could give their proxies to their friend who's actually going to attend in person, okay? But you would not count any of the people on the virtual chat line, if you will, as actually being in attendance at the meeting. And they couldn't make any motions, they can't vote on anything virtually. That's the way it is right now. So can you leverage technology to allow those folks that can't be there in person to actually hear and see what's going on? 100%, yes, but they cannot participate. They would need to get a proxy to do it for them right now. And September, I don't think we're going to be there by September. And so there was a follow-up to this that says with voting and budget ratification via mail. Well, we can always, and I'm going to back up again. I know, Jen, I get paid to talk. So this is what I do. Jen's used to me for like 21 years now. She's been here the whole time. She's had to suffer through me that entire time. So what we're really talking about is, hey, Adam, can we get people to vote? That is to ratify the budget or approve the budget if your governing documents require it. And can we do that all through the mail in lieu of having the vote at the meeting, and then allow people to attend a virtual informational meeting and have some people in place? Sure, you can. And the reason why is that you do not need a quorum to actually ratify the budget. The budget is ratified the moment that you call the meeting and attempt to open the meeting, if there's no quorum, okay? So yeah, you can do it that way. And so, all right, you want to hit me with another one, or you want me to take this?
All right, no, we've got a nice little pile here. So I'm gonna start with this next one, which is legally, can we postpone an annual meeting from November until December?
Well, when you say legally postpone it, I think what you're asking me is, if our governing documents say that it's supposed to be in 1 month, can we push it back a month or two and hold it a little later? Yeah, you can. And the reason I would say that is that no one's going to be able to file a lawsuit or get in front of a judge to force you to hold it any sooner. And as long as you're acting in good faith, right? And maybe let's say in this particular scenario, you're saying, hey, look, we've made the business judgment that we think the governor's executive or the governor's going to put an executive order in place, or that these bills are going to become law. So if we just delay it a couple months, we'll actually be able to use virtual member attendance, which actually garners more member support and more member participation. And courts like those things, right? And members like those things. So you're probably going to be all right. In general, at law, I shouldn't say in general, but at law, the board is the one who determines the date, time, and place of the membership meeting. It's only when your governing documents get mucked up that where it says it has to be this month, or it has to be this weekend, or this day. But when I draft my documents, I give the grace to the board to be flexible, so it doesn't have to be the same date every year. And so if that's the case, then it's perfectly 100% legal to do it.
If another COVID executive order goes into effect, can an annual meeting be held via mail only?
Okay, so I want you to remember this distinction. Voting by written ballot through the mail is not a meeting. It doesn't count as a meeting. It counts as action in lieu of a meeting, okay? And the word in lieu basically synonymous with in place of a meeting, okay? It's not a substitute for the meeting, however. Now, do we have associations that decided to have everything voted via written ballot through the mail and then hold an informational meeting? Yeah. Does that technically qualify with the the statute saying you have to hold a meeting, it doesn't. But what I'll tell you is there are no damages if you do it that way, because your board election has been effective, your budget ratification approval has been effective. Everything that you were trying to do at the meeting, you did outside the meeting effectively. So there wouldn't be any liability. There wouldn't really be anything right for someone to file a lawsuit on. So yeah, you totally could do that.
Great. Can you talk a little bit about how nominations from the floor work with a mail-in ballot?
All right, let me back this up, right? And I know Jen sent the link, right? Remember this, when you're doing action by written ballot, right? And I say written ballot, that's a term of art. That means it's going through the mail in place of a meeting. Since you're not holding a meeting, nominations from the floor are not appropriate. It's not triggered. So you don't have to allow it. Okay, so get it out of your mind. There are no nominations from the floor. Now, what I will tell you, what I do is best practices. I do two things. If I'm going to be voting by written ballot for boards, I do two things. Number one is I send out kind of about a month before I think I'm going to send the ballot out, self-nominating forms to allow anybody who wants to be on the ballot to be on the ballot. Okay. I can't stand it. It's one of my pet peeves. You guys have heard me speak before. I have several pet peeves. I don't like it when boards try to prevent people from running for the board, except in one instance. If you're delinquent on your dues or you're in violation of association rules and regulations, I don't think you should be entitled to run for the board. Okay, I think you should be disqualified. And I draft my documents that way when I do that. But outside of that, there's no good reason not to let somebody who wants to run for a volunteer board to run for the board. If you have different psychological, physiological, political, whatever, different views, it doesn't matter. Ideological, doesn't matter. They should be put them on the ballot. Now, I do have associations that don't like that. They like to control who gets on the ballot and who doesn't through a nominations committee or otherwise. To those people, what I would say is fine. You're not going to follow my first rule of thumb, then you follow my second rule of thumb, which is that on that written ballot, I generally will include blanks for write-ins. So if there are 3 board spots open for election, I'll have 3 write-in lines to allow people to write their name in. I've been doing this 21 years. I've never seen a write-in ever get elected. But I have seen a lot of people come close, and it's a good thing to do, right? So that's what, to me, that's what you should do. If you're not going to have the vote at the meeting, right? Nominations out the window, no such thing. Can't nominate somebody from a floor at a phantom meeting because it's not happening, right? And so that's how I would handle it.
Thank you. And so we've got 2 questions that both relate to delinquent board members. The first one is, or members in general, if an owner is behind with their dues, can they be kept from voting? Okay. So can you suspend someone's ability, right, and or privilege to vote because they're not paying their dues or they're in violation of the rules, right? The answer is yes, you can. When I draft my documents, I make it automatic that you lose your right to vote when you become 30 days delinquent, that it automatically happens, and I put that in the bylaws. Short of having automatic language in your bylaws, which is where it needs to be for being 30 days or more delinquent, you would actually have to send a notice of violation, which is no less than 10 days, hold a hearing, and then suspend their voting rights at that hearing until they become current, okay? So you can do it. It can be done. And you can suspend voting rights for them also bringing glass bottles to the pool, or, not using the restrooms properly at the pool, whatever the case may be. But you can totally do that. What about if you have someone on the board and then they become delinquent?
So this is a little more tricky, right? So I'm just gonna I'm gonna set the stage, right? Members elect the board at the annual meeting. We've already been discussing this. This is a big topic, right? Or they elect them via written ballot. So what the law says in North Carolina, when it comes to a nonprofit board, like a homeowners board, that is not a public charity board, there's really only two ways that that person can get off the board without a vote of the membership to remove them. The first one is if they sell their home in the community, right? They cease to be a member because they'd have to be eligible. Most associations demand that you're a member in order to serve. Some don't. You got to look at your governing documents, but that would be one. And number two is if you miss 3 consecutive meetings, board meetings, then you get the boot. But you can be totally current on your dues, get elected to the board, stop paying your dues, have your voting rights as a member revoked, but your voting rights on the board still stay in place and you still stay on the board even though you're delinquent. Now, in a case like that, what I would do is I would immediately call a special meeting of the membership. That is, the board would do it, the president can do it, or 2 board members can do it, or 10% of the membership, or 20% in the condo. But the point is, I'd call a special meeting to ask to have that board member removed. Okay, now you got to be careful because you can't tell them that they haven't paid their dues, right, under the Fair Debt Collection Practices Act. But what you can say is, this member is not in compliance with the association's governing documents, and we as a board recommend that you vote to remove them. Thank you so much. Have a great day.
And follow up to that answer, Adam, who has the right to call that meeting? The manager?
Okay, so let's go. I'm gonna go backwards, right? We're talking about annual meetings and membership, but I'm gonna talk about board meetings. So when it comes to board meetings, the president or 2 members of the board can call a board meeting. When it comes to a membership meeting, that is a meeting of the members, either the president, 2 board members, or 10% of the membership in the case of a planned community, 20% in the case of a condominium, that sign a petition demanding a special meeting be held for a proper purpose upon which the members can vote. So if you don't like your board of directors, for example, and you're just fed up, you can go around and collect names on a petition that says, hey, I want to remove Adam Bowden from the board. And you get a critical mass, you turn it into the secretary hands it to the lawyer says, yep, they meet the qualification. You have to call that meeting within 30 days. Now, if Adam's on your board and Adam's your president, and there was a petition going around saying, we want to remove Adam as president, well, the members don't have the ability to remove me as president. Only the other board members can get rid of me as president. So I can be removed as president, but I stay on the board. The only way to get me off the board is with a vote of the members.
Yeah. So switching gears just a little bit, we did have a question regarding electronic voting, so such as Election Buddy or something along those lines.
Yeah, the answer is no. Okay, I mean, I'm not going to go into the nuance right now. The answer is no. Probably once this new legislation passes, the answer will be yes, but the answer is no right now.
I really like this next question because as an event planner, I'm running into some similar situations. So what happens if you cannot find a venue to hold in-person meetings?
You just gotta look harder. I mean, I'm sorry, no, that's, I mean, you just have to plan for it, right? Or you just have to, pick a place. I mean, a lot of folks during COVID were having outdoor meetings in parking lots, in common area parking lots and stuff like that, and having folks bring their lawn chairs or their camp chairs or whatever. but you know, it can be a little weather dependent and depending on the time of year, but you gotta, it's not, let me put it this way. It's not an excuse, okay, to, oh, well, we can't find a place that's big enough or no place will rent it out to us. Okay, well then let's change it. Let's do it outdoors or let's figure out something else. But it's not an excuse that you can't find a place. That's going to fall on deaf ears.
And as a follow-up to that, would you see any issue with renting out a clubhouse from another HOA as a venue for your annual meeting?
Oh, not at all. No, I mean, unless your governing documents say the annual membership meeting must be held at the clubhouse at such and such an address. Again, the board has the flexibility to determine where it's going to be held. And I think using other associations' clubhouse is a great idea. And they love it because the other association makes some money. And it's just, it's a good way to help each other. Who knows? Maybe you give, you know, share amenities or something like that, hand out a bunch of pool passes if they don't have a pool and you know, you don't have a clubhouse, but yeah, that's a good idea.
Great. So we do have a few more questions. The next one is, what happens if we don't have enough people in attendance to hold an annual meeting?
Right. This is the old quorum question, right? So quorum is this magical word, which basically means that you have got enough bodies in the room to have critical mass where the members can take action. There's usually a minimum threshold. And the reason for this, right, is that you don't want a small percentage of the association making all of the decisions for a supermajority, right? So North Carolina law sets the very minimum of for a planned community of a quorum at 10%. For a condominium, it's 20%. But most of the time, you will see a higher quorum requirement. You'll see 30, 40, sometimes I've seen 51%. And so if you call the meeting and you don't have critical mass, that is, you don't have enough people in attendance in person or by proxy, well, we know, because I already said so earlier, the budget is ratified, right? It happened magically. You tried to call it, didn't get quorum. Statute says the budget's ratified. Okay, so what do you do next? Well, what you need to do is you need to recall that meeting. You need to call it again. And there is some language in the statutes that allows you to cut your quorum in half the next time you call it. So what you would do is send out another notice of meeting. And let's say your quorum requirement was 20% that time, it'll be 10% the next time. So you basically keep trying till you get the minimum number of people there, but the budget was ratified the first time you tried and failed. So really, sorry, Jen, but so here's the thing. If you're really having trouble getting people show up, I got lots of tricks up my sleeves, and I do have sleeves, okay? So I got lots of tricks, and when you talk about them, I'm not giving away that milk for free, but I just know it's out there, okay? So go ahead, Jen.
Great, thank you. You touched briefly on annual budgets. Can you go through the procedure to adopt an annual budget?
The dreaded word adopt, right? So I got to go backwards here. I got to go back. Okay. So at baseline, your governing documents say nothing about approval. Okay. State law doesn't say anything about approval. State law says ratification. Okay. So here is the deal. Let's say you're in a community that has to ratify the budget. This is how you do it. Treasurer gets up. Hey, these are our expenses from last year. These are our anticipated expenses this year. This is what we anticipate we're going to need. Now, granted, I'm basically taking 30 minutes of time and compressing it into 10 seconds, but you get the gist of it. And then you say, are there any questions? I like a nice long pregnant pause. I usually count 5 Mississippi in my head. Hearing none, I'll drop the gavel, metaphorically speaking, and say, okay, pursuant to North Carolina law, the budget has been ratified. You're not calling the question, okay? If your documents are silent and you're relying simply on the statute for ratification, you do not call for a vote, because remember, the budget is ratified unless it is rejected by a majority or greater number of the entire membership, okay? And so if in that case, right, where I had one community for 3 years in a row where they failed to ratify the budget would be presented, person would raise their hand, say, Madam Chair, I'd like to be recognized. Yes, Mr. Smith, I would like to entertain a motion to reject the budget. Okay, Mr. Smith, this community had 500 homes. Mr. Smith had 350 proxies. I vote all my proxies against ratification. Budget not ratified. That's how it goes. Now, I've had that happen where someone says, I make a motion, we reject the budget. And I will say, sir, madam, I appreciate that motion, but you're out of order. There are not enough people here to reject the budget. Therefore, it is automatically approved at law. So I want to pause there because I'm going to move to this concept of approval, right? So in a ratification context, okay, in a ratification context, you are not asking the question. You're not calling question. You're not asking for a vote. There is no vote unless someone wants to reject it. There's no vote for approval. Now, if your documents say that the budget must be approved by a specific number of members in attendance, then yes, at that time, you would put it out to a vote. And you would say, can I get a motion to entertain approval of the budget? We need a majority of those in attendance. And you have your vote that way. So you really have to know what your governing documents say about the budget, right? Some governing documents I've seen say that the board can raise it unilaterally on an annual basis, 5% without the vote of the membership. Okay, great. That's an approval vote, but you still have to have it ratified, okay? That doesn't mean that it automatically happens. But if you go over that 5%, now we're soliciting an approval vote. So I don't know if there's any other questions or any follow-up on that, but we could probably do a webinar on budgets, quite honestly, for those 41 people that are still awake.
Thanks, Adam. We did have a follow-up question when you were discussing quorums. And the question is, on a quorum, you state that 47F says it goes down to 50%. Is that for every HOA, even before 7/1/99?
No, it's not. So I mean, it used to not be, but it's generally for 47F only. Pre-47F, I'm pretty sure that it doesn't apply to anybody pre-47F, but you can put it into your documents or you can amend it. For 47C, I think it does, because 47C is a little different with the Condominium Act.
Okay. All right, I think we've got time for about 2 more questions. So the next one is, if a new budget has an increase of dues and the budget is ratified, what is the next step for the increase?
So it's been ratified. What's the next step for the increase? Send out your bills. Right? I mean, the board gets to decide how dues are, you know, how dues are essentially paid. That is, are they paid annually in one payment? Are they paid quarterly? Are they paid monthly? But that's a decision for the board as to how they're going to be paid. Now, what I would say is, and I see, wouldn't you send out a dues notice? Yeah, that's what I'm saying. You send out a dues notice, right? But what I want you to think about is, what's the best way for your community for you to get paid, right? What is going to give you the highest likelihood of getting paid by the greatest number of people? And so I give you an example. We have a very large gated community here in Wilmington that has very high dues. They allow people to pay monthly because most people probably wouldn't want to spend $10,000 in a single annual drop. they want to space it out among 12 installments, right? But in a smaller plan community that doesn't have any amenities, that let's just say your total dues for the year are $250, or maybe your total dues are $500, maybe you're going to pay quarterly, or maybe you're just going to pay in one fell swoop. But here's the kicker though, everybody has to pay under the same timeline, right? And if you're 30 days, you're delinquent.
Okay. All right. So we don't have any more. Oh, I'm sorry. We had one more. So that approvals the increase was the next comment on that.
Yeah, that's exactly right. Once the budget is ratified, that is your number, right? That is your budget number. And then you break that up. If it's a condominium, it's going to be based on percentage of ownership interest, right? A 3-unit is going to pay more than a 2-unit, et cetera. But in a plan community, it's usually pretty equal. And that's what it's going to be. So you just go forward. So part of that, before I leave this, Jen, you have to think about your annual meeting from a timing standpoint, right? Which is, okay, we want our dues notices to go out January 2nd. So that folks are delinquent if they don't pay by February 2nd, right? Or February 1st. So when do we need to have our annual meeting? Well, clearly you need to have your annual meeting sometime in the middle of December so that your manager and everybody has enough time to put together the notices and mail them to get there in time. And so anyway, when it comes to, I saw a question here just pop up about late fees and interest and stuff. Those are very document specific. And they're also tied to the statute. You have to be pretty careful about it. What I'd say is you need to talk to your attorney about that, because collection law, if you mess it up, right, which is easy to do because there's certain caps on what you're allowed to do, but you also have to look at your governing documents, because your governing documents may exceed or may be less than. So I'm not really, it really depends on your documents, and you got to talk to your collection attorney, because there is no hard and fast baseline. I don't want to get you into trouble because you go in front of the clerk and you're trying to foreclose on a lien or something like that, and you mess it up, you're going to have to start all over again.
Okay. Well, in the interest of time, we're gonna have one final question. And I feel like I saved a good one for the end. So Adam, how do you recommend our association managers handle disruptive members at an annual meeting?
Well, I guess the first question I'd ask is, do you anticipate disruptive members, right? Do you have reason to know they're going to be there? I have been through some pretty terrible meetings. I've actually went to a really terrible one a couple months ago up in Jacksonville, North Carolina. And what I would say is this: whenever I know that I'm going to have to batten down the hatches and prepare for heavy waves, I will request the association hire 2 off-duty police officers or off-duty sheriff deputies. You usually pay them $50, $60 an hour. Sometimes they might charge you $100, but they're well worth it. Have them come in uniform, have them have their firearm, their sidearm, and their taser with them. And I'll typically have them standing by the door as people come in through check-in. And I usually like them to kind of scowl at the members too. I'll tell them, like, just kind of be real serious because you're getting paid, right? Generally, when you do that, it kind of sets the tone. I haven't had a lot of trouble. Now, there have been some times when I've had 3 sheriff deputies at a very large meeting. The chair will appoint them as sergeant at arms at the meeting under Robert's rules. And I've actually had sheriff's deputies escort unruly, disruptive members out of the meeting. Where they're dropping F-bombs, they're trying to fight other people. I had a guy pull a gun a couple times, right? Like, there's things that you want to get in front of. So that's how you deal with the disruptive member. If you think that that's going to be the case, being proactive. There are some disruptive members that are just folks that will continue to make motions or continue to try to, they're not really violent. They're not really mean. They're just annoying, right? And those are the type of people where if I'm running a meeting, I will say, hey, look, understand you got a lot of questions. I promise I'll give you 30 minutes of my time at the end of this. We can go find a quiet corner and I'll talk with you. But we got to get moving. We got business that we've got to move forward with. So I promise I'll answer your questions, but now's not the time. Thanks very much. And then I won't recognize them anymore from the chair, right? Now, in Jacksonville, in this room of 250 people, I'm pretty sure almost every man and woman could have killed me with their bare hands in that room. Okay. I mean, most of these people are folks that protect our country and our nation's freedom, right? And they're trained to do that. So I was as deferential and respectful as I could be. And that's, you know, you're going to have folks where this is their home. It's their biggest investment, right? So they're very, you know, emotions can run high. I just try to diffuse it. And a lot of times if you have uniformed officers or deputies, it helps to keep people mindful of who's really in charge.
Thank you so much, Adam. And thank you to all of you who attended today for the great questions and the great discussion. So following the webinar, we will send you an email with a list of articles related to what was discussed today. We'll also include a recording of the session and a link to sign up for our Community Association alerts. We so appreciate you taking your time to join us today. Hope you're able to take some of the information you learned and apply it to your own organization and annual meetings. Thank you again. And that concludes today's webinar.
Thanks, everybody. Thank you so much, Jen. Great work.
Adam.